Welcome to this webinar organized by the QPMA in collaboration with BCF Business Law. I am Marie de Tarlet, Director of Public Affairs at the QPMA and moderator of this webinar. This meeting is recorded, so we will be able to forward it to you for review. Today, we are welcoming BCF expert, Mr. Pascal Lauzon. He will present Bill 96 and the amended regulation on the language of commerce and business, which will come into force on June 1st, 2025. He will give you examples of how these regulations affect and will affect the use of your trademarks and your business relationships. Here is the schedule for the next hour. I'll start with the biography of our experts. Then Mr. Pascal Lauzon will present Bill 96 and its regulations. He will then answer your question. Here are the practical instructions for making the most of this webinar. Your microphones and cameras have been automatically disabled to ensure the smooth running of the event. You can ask your question and share your comments at any time during the webinar via the chat tab at the bottom of your screen. We'll come back to this when it's time for the Q&A session. Meet your guest speaker, Mr. Pascal Lauzon. With over 20 years of experience at BCF, Pascal Lauzon is one of Quebec's leading specialists in intellectual property litigation. He acts quickly and efficiently with a pragmatic approach to either prevent infringement of intellectual property rights or defend a business accused, wrongly or not, of violating the intellectual property rights of a third party. Pascal practice focus on trademarks and patents, as well as on copyright industrial design and trade secret issues. A mediator certified by the Barreau du Québec, he helps businesses find practical and constructive solutions to their commercial disputes. He also assists clients with various regulatory matters involving commercial signage and advertising, such as the requirements of the Charter of the French language, as well as relating to electronic communications and labeling. Pascal is recognized as a trademark agent by the Canadian Intellectual Property Office, CIPO, and sits on the Trademark Opposite Board Chair Advisory Committee. He is a pillar of BCF's intellectual property, internet, and litigation groups. Without a doubt, we have the right person to guide us through Bill 96 and its regulation. I invite Mr. Pascal Lauzon, lawyer and trademark agent with BCF Business Law, to introduce you to Bill 96. Mr. Pascal Lauzon, the floor is yours.
Yes, thank you, Marie, and thank you to the AQDFL for inviting me today to speak with you. Marie, I can't open my camera.
No problem, I'll do that.
Because the host has stopped it.
Okay, no problem, I will do that. No problem. Pascal, can you...
I can open my microphone, but I can't open the camera. I'll start my video. Okay, I think that's good. Okay. Hello, everybody, and happy Halloween. So I'm here to scare you with very frightful Quebec language laws. No, just joking. To the contrary, I think there's a lot of bad press and misinformation about the scope of these laws, particularly what we'll be discussing today. So the objective is more to demystify uh, these regulations and to assist you in understanding the very, I would say, minor changes that Bill 96 has brought to the Charter of French Language in terms of labeling and signage. So before actually getting into the subject matter, we just maybe a brief historical background. Back in the 50s, 60s, and early 70s, when somebody would come to Montreal, for example, would probably not be able to know that he was in the second most populous French-speaking city in the world, as signage was mostly in English. Businesses downtown would greet people in English. People in factories and shops would quite often need to work in English because the businesses were English owned or American owned. And immigrants coming into the province would quite often prefer English school rather than French school because, the overall context of North America. So when the Parti Québécois got elected in 76, they enacted the Charter of the French Language in 1977, also known as Bill 101. And so that made it mandatory for signage to be in French. Businesses incorporated under Quebec law need to have a French name. So sometimes you see businesses preferring being incorporated federally to avoid that obligation. And then the charter also provides the right to be served in French in stores, the right to work in French, and the obligation for newcomers to the country. This applies only to foreigners. I mean, not to English Canadians out of province, but to people coming into the country and going to public school had to have to attend a French school. So that has had some effect in how can I say it, in diminishing the pressure on French language and culture in Quebec, and has brought it to some sort of status quo. And of course, it requires costs and some hardship on companies to comply with all these regulations. But there's not more than respecting environmental laws, labor laws, paying taxes, and whatnot. So it's part of the cost of doing business in Quebec, and it's a cultural society choice that's been made, and and that's what we're going to talk about today. And so now Bill 96. A question I ask is, why does Bill 96 come after Bill 101? It's just a simple issue of legislatures after each election, and this is the same for all parliaments in Canada. The counting goes back to one after each election. So Bill 96, what it did is it brought added additional obligations under the charter, and some of which in all fields, so not just in signage, but in labor, contract law, litigation. But we'll be focusing on labeling and signage. And what we need to understand basically is that the Charter of the French Language essentially imposes the use of French and limits to certain extents the use of a language other than French. I know that there's a perception that it's aimed at preventing the use of the English language, and between you and me, that's probably the main objective. But in essence and in practice, it applies to all languages as that term is known. So which brings us to the question: what is French? And what is a language other than French? Because so there's a bit of linguistics to be done in each case, because languages evolve. So when did Latin become Old French, become regular French, and when did a certain word that used to be French come out of usage? When does a foreign word that's commonly used officially become a French word? So those are all interesting questions, and they can be debated before the Office québécois de langue française, the OQLF, if ever there's an issue, whereby they're alleging that you're not using French. And as an example, in 96, was it 96, 2006? I don't know, some 10 years ago, there was an amendment to the charter of the French language regarding the use of trademarks in public signage. Now, there's a big exception we'll be discussing today, is the use of a trademark in a language other than French, which has been there since the beginning of the charter. And some 10, 15 years ago, they added the obligation that if you use a trademark in a language other than French, then yes, you can, but you must also use, there also needs to be a sufficient presence of French in the signage. And we'll discuss this a little bit more later, but just coming back to my example, the Scores restaurant chain. I don't know if some people out of province don't know it. It's a chicken and ribs sort of restaurant, and it's called Scores. And some of the signage already said Scores, poulet, côte levée, chicken and ribs. But some of the signage was just Scores, without any generic or descriptive term in French present on the signage. And so they called me and say, well, is there anything we need to do, because we have now we need a sufficient presence of French on our signage. And my first reflex was to, it's not because we pronounce it Scores in English in the marketing or colloquially, but score is a French word. I mean, it's originally an English word, but it became the verb scorer, so to score, and you score is tu score, takes an S. Les scores, the scores, like the Montreal Canadiens bad scores recently, is acceptable French, and we decided that everything was okay. So you just need to look up in dictionaries. That helps a lot. And sometimes, but there are many languages, and because there's an exception also, is if a word is in no language whatsoever, it's a made-up word. For example, Kodak doesn't mean anything in any language, so the charter doesn't apply to that. It doesn't count as a word in a language other than French. It counts as a language as a word in French. And an example I have regarding that is hold on, I can't see my notes here. Was a couple of years ago, we had same situation. I don't know if you know the company Aon. It's an insurance company. They asked us the same question because their offices are a couple of buildings down the street, and they have Aon on the top of the building, and they wanted to know if they needed to add assurance under it to have a sufficient presence in French. And my reflex was well, Aon is not a word in any language. And they came back to me saying, yes, well, Aon is an Irish company, and Aon means one in Irish Gaelic, which is theoretically, and not just theoretically, in practice, it is a language, not spoken very much, especially not in Canada, but still, it's a language. So what do we had to do? We reflected on it. I think, technically, legally, we would need to add assurance under or beside the signage. However, if people don't perceive it as a word in a language other than French, then the risks are very, very low, because somebody needs to first of all, the OQLF probably won't go around looking at words that they don't know what they mean, and they'll may go after the English words a little more, but they don't typically go out to. They're often referred to as the language police. But that's a caricature because they don't actually go out and police things. They work most on the basis of complaints. So if somebody sees Aon, doesn't know it's a word in a language, probably won't file a complaint. So that sort of settled it for now. And if ever we do get a complaint, we'll talk about that at the end of the presentation. Another example, which was kind of funny, we had a client that was called Cafection. which was a coffee that sold coffee machines, and Cafection was for café, perfection, two French words, sort of blended into a make-believe word. It's not a word in any language, so the company could be incorporated as Cafection Inc. But then they later wanted to change their name to Evoca for Evolution Café, also an invented word, but at the registry of businesses where you have to get approved there's actually somebody that checks and approves the name change or not, said, well, evoca means he evokes in Spanish, and refused it. So that was kind of frustrating, even though it's an invented word, is invented, but coincidentally a word in another language. So that's something you need to consider. But in that case, all we needed to do was to add les entreprises, Cafection, Evoca Inc. to make it compliant. And finally, I mean, it's not just an issue of words existing in French. It's also a question of syntax. We're a little too fast. Let's get back to the previous slide. And the example I give here is like ABC Technologies. ABC, that's French. Technologie is French, but the order, that's typically in English, whereas in French, we would say Technologie ABC. So that's something that needs to be considered as well. Next slide. Now, so we will be discussing today with this mindset of what French is and what it is not. We'll be discussing how we can use other languages on packaging and labeling. And Bill 96 brought some minor changes to that. So I would say most probably doesn't affect the labeling and packaging of most products. So that's good news. In commercial signage, major changes. But as most of the members of this organizations don't necessarily have stores per se, and signage won't affect many of them, but still we'll look at that and see what needs to be put into place if necessary. And finally, what didn't change at all is the promotional materials, so catalogs, flyers, and websites. So no changes. So that's all good. Now, so keeping in mind that we'll be looking at three different contexts: labeling, signage, and promotional materials. There are four general exceptions for that are allowed that permit the use of a language other than French. Now, the name of the firm or the company, if it's established outside Quebec, then doesn't need to have a French name. So that's all good. The name of origin, the denomination. Oh yes. So what's relevant to use? Well, for example, Shishtaouk, which literally translates to chicken skewer, could be used in Arabic, as can osomaki, which means I think medium-sized roll in Japanese, because they're exotic products. So if you're importing into Quebec exotic fruits and vegetables that don't necessarily have a French word for it, well, that's all good. And then place names, for example, city names like New York. Well, there's no French equivalent for that, so that's not an issue. But some people ask me the question, how about London? Because in French we say Londres, but no, it's an exception. You could use the English word for London. Family names, McDonald's, for example, is a good. Or if your family name is actually a word. For example, I gave a similar conference to the Auto Dealer Association a couple of months ago, and Ford is a family name. It is like Henry Ford, I think was his first name. But Ford is also a place where you could cross a river. So, but since it's a family name, it's something you could use without any issue. And finally, the exception we'll be discussing the most today is a recognized trademark within the meaning of the Trademarks Act, unless a French version has been registered. So what is a recognized trademark? That's the first question. The OQLF originally took the position that in order to be recognized, the trademark needed to be registered, which I would say is a good stamp of approval, because if the Registrar of Trademarks registered the mark, he recognized it as such. But the Trademarks Act has a much broader definition to a trademark and actually grants rights to unregistered trademarks, as you may know, like so you can enforce your trademark rights through an action in passing off if you've used a trademark that hasn't been registered. And so that's being debated before the courts, and the courts, the Superior Court of Quebec did recognize that if your trademark corresponds to the definition of a trademark, which is essentially a mark or a word or a sentence or a phrase that is used to distinguish your products and services from those of another, or is adapted to distinguish as such, is a trademark. So that's the definition. So if it corresponds, it's a trademark, and it's a valid exception. Now, the OQLF was still trying to, I mean, they have a political role, I suppose, and they're trying to push the use of French, sometimes a little more than the statute allows them to. Now, that's an editorial comment, but it's also based on my personal experience. So they still, sometimes it was difficult to get them to back off on a complaint saying it's a trademark. So what we typically did, and when I say we, I don't mean just my firm, but it was common practice in law firms in Quebec to file a trademark application, say, listen, we have a trademark application pending, and then they say, okay, well, they would back off, which is good, but then it still required some extra and sometimes unnecessary costs, and we'll be discussing about that a little more later. Yes, so then when Bill 96 came out, and that was a major issue. Bill 96, the amended Charter of the French language, specifies that only a registered trademark can benefit from the exception. So that raised like that was a major change that I would say caused a lot of bad press and a lot of worries in businesses. And I remember I had a discussion with people from the U.S. Embassy and U.S. Consulate about this, and they were really worried because they represent, the American business interests, and a lot of small businesses were concerned. And I was having a video conference with them on my lake at Lake Memphremagog. I don't know if you know it, but it actually flows into Vermont, like 5 kilometers away from Vermont. I could boat to Vermont, which I do once in a while because I have a nice restaurant there. And they were worried because the small businesses selling locally could find this undue hardship, having to register a trademark. I mean, it costs money, takes time. Not all trademarks are registrable, and people, were fearing getting fined or whatnot because of this. So there was a lot of political pressure on the government to back off on that, and I would say not just from the U.S. government, but from major business interests. And then when the first draft of the regulations for dealing with the language of business and commerce came out, there was sort of expanded the definition of a registered trademark to a trademark that's the object of a pending trademark application. So it essentially said it will be deemed a registered trademark, a trademark that's the object of a trademark application, which was good to a certain extent, but not which I would say was better or least bad, because again, you still need to spend money to register, to file an application. You're never sure it will issue, and if it doesn't issue, then what happens? You refile. Still, you're considered. You could be considered in breach of the law retroactively. I mean, that raised another bunch of questions. So then finally, lo and behold, surprise, in June of last year, when the final version of the regulations, the regulation amending the regulations of the language of business and commerce was officially adopted and published, we go back to the same exception as before. So only the exception applies to all recognized trademarks under the Trademarks Act. So this is a very odd. I mean, this is good news for businesses and for business liberty. But it's a very peculiar way of doing things, because you have a law, an act from Parliament that changes the law, and then you have a regulation that comes thereafter, which in the hierarchy of rules and laws is under the law that comes and sort of nullifies the law. So anyway, that's good news, and I think we could take for granted that it's going to stay that way, because that's the way the cookie crumbles. Now, the exception to the exception is unless a French version is registered. So the exception is you could use a recognized trademark that's in a language other than French, except if there's a French version that is registered. And so quite often we have clients that come to us and they have an English trademark and a French version, and they want to register both. So we typically say, well, hold on a second. It's probably better not to register the French one if you want to keep your right to benefit from the exception. And then they go back to us, well, yeah, but won't that affect my protection if I want to sue somebody that uses a similar French trademark? But then the answer to that is not really, because in the confusion test for trademark law in Canada, you look at, you compare two trademarks from the perspective of the unilingual English-speaking Canadian, from the perspective of the unilingual French-speaking Canadian, and also from the perspective of the bilingual French English-speaking Canadian, such as myself. And that comes from a case of several years back where there was a product that came out. It was like a chocolate nut spread called noixel, noix being the French word for nut. And that was the argument that was made, but the court concluded, no, a bilingual Canadian knowing Nutella would see noixel and would think that it's like the French version of that trademark. So that settles that. So no rushing getting your French versions registered. No, quite often useless, except in some cases. So and there's a few examples here. So I'm thinking of Kentucky Fried Chicken. They've registered Poulet Frit Kentucky, which is a literal translation. So Kentucky Fried Chicken in Quebec can't decide to have an English bannered Kentucky Fried Chicken, let's say like in the west part of Montreal, where the population is mostly English speaking. So they're stuck with that. Now there's other trademarks. One we see a lot also is the Bureau en gros, which is the French version of Office Depot. Now that's not a literal translation, but is it a French version? I would say it's debatable. And then you have, in some cases, like Shoppers Drug Mart and Pharmaprix, which is definitely not even close to a translation. Well, there are two different versions. So I would say, I would argue that Pharmaprix is not a registered version of Shoppers Drug Mart. So if they ever wanted to open an English bannered store in the West Island, they would be allowed to do so. Now, okay, moving on to the next slide. So speaking of so just going back a second, we just discussed the exception. I just defined the exception regarding trademarks in a language other than French. Now we're moving on to how does all that apply to actual labeling and packaging. Now the basic rule, there's always exceptions, and we'll be discussing some exceptions, but I just want you to understand that there are many more exceptions than those discussed. I'm just sort of discussing those that are most relevant to your industry. So the basic rule in labeling and packaging is that everything on a product or its container or the papers that come with it, like an instruction manual or whatever, need to be in French, period. Okay, it has to be in French. It could also be in another language or other languages, plural, as long as they don't predominate the French on the labeling. So everything needs to be French needs to be at least the same size as the writing in the other language or bigger. So French could be bigger, but I think it's as common practice to make it equal, because sometimes most products are sold Canada-wise, but we see this in certain more local Quebec products where the labeling is predominantly French and a little smaller in English. And I'll give you an example I had a few years ago. We had a client that sold various products, like hundreds of products in Canada, using either the US English only packaging, but knowing that Canada was a bilingual country and that there were Quebec language laws. They didn't know about the federal language laws. We'll talk about those later. They tried to sell as much as possible the products using the European labeling that was used in the EU, which was English, French, German, Spanish, and Italian. But the problem was that the English was written bigger, and all 4 other languages were a little smaller. So that gave rise to an issue, and we resolved it by changing the packaging to making all 5 languages of equal size. And also, that was like a lot of work. I mean, we're talking dozens and dozens, over 100 different products manufactured in China. So the client had to have new dies made for the printing, first design the new labeling and whatnot. But so that took a lot. It took over a year to get compliant. But the OQLF was very amenable to the time it took, understood, that they don't want products necessarily off the shelves to deprive Quebecers of products. They just want companies to eventually comply with the law, and they're very reasonable. And that's why people don't understand, but I know from practice that if you show good faith intent to comply and you have valuable business reasons why you can't comply by clicking your fingers, and it takes time, they'll be very open-minded about that, and they'll set a schedule. They'll ask you to provide them with a schedule, and then they'll ask you to comply with it. And if there's an issue, for example, there's a hurricane and whatnot, and, problems happen, they'll be open to providing extra delays to comply. So that's also, I think, good news. Now, what other exceptions apply that are relevant? I mean, so you have the packaging, the labeling needs to be in French or another language, same size. So, but there are exceptions. So we just discussed, for example, the 4 exceptions we just discussed. So place names, a trademark in a language other than French, you don't need to translate the trademark. The text on, if it's an internet, this is very interesting. The text on containers used in interprovincial or international transportation can be in any language, doesn't need to be in French at all. Products that are intended to market outside Quebec. So if you're a Quebec apple grower and your apples are being all sent to New York, you could put them in an English only box. If for fruits and vegetables, also very relevant, if you get a box of bananas coming in, it's in Spanish or English, that's good. But as long as the bananas are taken out and put on the shelves without the unilingual or non-French labeling. So moving on, here's an example that's provided by the OQLF as being a compliant labeling. It looks very similar to a Colgate or Crest toothpaste tube, although Colgate is probably not a word, but Crest is an English word, so that would apply. So we have Happy Teeth, which is a trademark. As you can see, it's there on both faces of the, you can imagine it's like when they're on different sides of the toothpaste package. So Happy Teeth is there on both, and everything else is translated, same size, same font, same colors. So that's all good. It could be above one another, beside one another, or on different faces. So that's all good. And that doesn't. Well, that's how it is now. So what changes? What did Bill 96 bring in terms of additional hardship? Well, not much. What it says is, like, the trademark exception continues to apply, but if there's like a generic or a descriptive term in the trademark, that needs to be translated. And the reason behind that is because some businesses, thinking they're smart, saying, okay, I'm gonna go around the act. I'm gonna register the full label as a trademark, and then I'll be scot-free with the OQLF. So that was a practice that we saw, for example, for wine labels, or where it could be all in Italian or just in English, and so that's a practice that sort of irritated, probably rightfully, the OQLF, and so they changed the law to provide that if there's so if there's descriptive or generic language in the trademark, that needs to be translated. But okay, and here's the example that they give. So if we move on, it's like a bottle of soap. So we have, let's say you registered the trademark Best Soap, as you see on the left, like the full label like that. Well, today that would not be contrary to the Charter of the French Language, but with Bill 96, oh yeah, I might have forgotten to mention, not coming into force until June of next year, so there's still time. So as of June 2025, that label would need to be changed, as you see on the right, with everything translated, but not Best Soap. And this is where the government's a little funny, because Best Soap for soap is very arguably generic, at least the word soap. Best could be argued that it's a descriptive feature of the product, but they're saying that it doesn't need to be translated because it's the name of the product. So I think that's not sound reasoning. I think they're just trying to backtrack on the ill effects of their legislation by providing, I would say, doubtful interpretation. But if that's the way the government wants to apply it, then so be it. So let's leave it at that. But as I say, it could change. I don't agree with the OQLF on that one, because usually, funny enough, they interpret the act more strictly than it actually is, but here they're interpreting it more broadly. So good for all. And here are actual real examples that are very interesting to discuss. So we have like the Del Monte Gold, the extra sweet pineapple. That's a registered trademark as such, probably registered like that for various reasons, but maybe to avoid the effects of the Charter of the French Language. But now, like, the question is gold, which is arguably the color of a pineapple, descriptive? Maybe. Quality? Maybe. Extra sweet pineapple? For sure. So you would need to add some text to your labeling if it's not already there. Other examples there as well. But the question is that obligation to put the generic word, the generic name of the product, next slide, please, is that really new? I would say, well, not really, because a law you're probably familiar with, the Safe Food for Canadians regulation, which is federal regulation under the Safe Food for Canadian Act, prescribes the obligation on the labeling of off the shelves food products that are sold to consumers, that the packaging be bilingual. I mean, it's a federal, and that applies across the country. So the regulations provide that the common name of the food needs to be on the principal display of the packaging. Same thing with the net quantity, then the name of the importer, importé par, or geographic origin, that is like produit des États-Unis, needs to be in French on the labeling too. And we joke often that's why that's how English Canadians learn French, by eating breakfast cereals in the morning and then reading their Kellogg's Fruit Loop box, because it's bilingual. So it's federal legislation, and that applies to not only to food products but to consumer products. Applies to to clothing. I mean, there's various regulations under federal law that impose the use of French on labeling. So for those businesses that say, well, I'm not going into Quebec because I need to put French on my labeling. Well, if you're going into Canada, you need to. So that's a good argument to say, well, hold on, buddy. It's a Canada, Canada-wide obligation. There are exceptions under the federal act, let's say in small localities where you have local products, that doesn't apply. But we're talking, you're all big business, importing, selling a lot of products, so that typically would not apply. But the main difference with the federal act and the federal regulations and the Quebec regulations is that Quebec imposes like different sizes French can't be, either needs to be markedly predominant or no other language can predominate the French. That's not in the federal legislation, which only provides minimal size of things, so you could read them. So no small print sort of obligation. But English could be bigger than French, or vice versa, and comply with the federal law. But so you could have a packaging where you have English is bigger than French, would comply with the federal law, but then would be contrary to the Quebec law. So might as well just put everything same size, very simple, everybody's happy. Now, what happens if your packaging currently is not? We're going back to the best soap example, where the label was clearly not compliant. Well, what happens then? Well, you have 2 years. If the packaging is already printed before the coming into force of Bill 96 next year, June of next year, then you have 2 years to get rid of to sell them off. Otherwise, you would need to relabel. Now, here's maybe 2 slides. Yeah, we just skip that one. Next one. Here's an interesting example that I saw in the fridge the other day. It's not produce, but still relevant. As you can see that, like, all the generic or descriptive words are bilingual, same size, pack, unité, real cheese, vrai fromage. Mozzarella is both accepted in French and English, only needs to be there once. Black Diamond, clearly the trademark exception applies there. And then this is where it gets really interesting, because cheese strings, well, is arguably a descriptive term, because they're like, you pull them apart and you have actual strings of cheese, which would be ficelle de fromage. But the French, and I'm putting French in brackets here, version of the trademark is ficello, which is not a French word. Ficelle with an E at the end instead of an O would be a French word, but ficello is not a French word. So this is interesting, because the Black Diamond, if that's the name of the company, would need to scratch its head saying, well, what do we do here? We leave it like that? Will it fly? Maybe I'm just too keen on this and catching things they won't. So we'll see. All right, moving on to it's already 1:45, and by yesterday I was almost done, but I tend to speak faster in French, so I'm sorry, we may go a little bit overboard. But more quickly on the next, so we're done with labeling and packaging. Moving on to signage. This is where Bill 96 changed, had the most impact. So as I mentioned before, since 2019, you need a sufficient presence of French on your signage, and that's further to that, we come up with things like Toys R Us Jouet, which is written under it. It's small, but it's visible, and that's the criteria. But what changes as of or what will change it? So if we go to the next slide, so yes, what changes is that as of June of next year, we're no longer satisfied with the sufficient presence of French on the signage. It has to be markedly predominant, which is defined essentially as taking up twice the visual space. So let's say you have 1 square meter of an English trademark, then you need 2 square meters of French on the signage. So the example here, so Vêtements Cool Kids being at the trademark that's exempt by the exception. Vêtements, as you can see, is a little smaller than Cool Kids, so it satisfies the current sufficient presence of French requirement. But as of next June, Vêtements would need to be twice as big than Cool Kids, as you see on the right. And next examples. So on the top, you have Vêtements cost list, which would be compliant today. But as of next year, rather than making Vêtements bigger, you could add descriptive words on the signage. So chaussures for shoes, mode pour tous, fashion for all. So it's not a question of, for some businesses, it can be easily corrected by just adding words on the storefront to make it compliant. And also, as you see in the second example, where they added Vêtements, which was not there before, but so Vêtements and the slogan pour habiller votre enfant avec style together make up more than more than twice of the space taken up by Cool Kids. Another small, well, for some businesses relevant or not, is the fact that also in counting what's visible in terms of French and a language other than French, if it's visible from the exterior, it counts. So if through the window you can see a word in a language other than French, then that counts too in the overall assessment. And as I said, I gave a conference to the Car Dealership Association a couple of months ago, and that was relevant to them because, as you all know, car dealerships typically have very, very, very big windows, and you could see from the outside everything that's on the inside. Okay, so moving on. Oh yes, a funny example, as I said. So for some businesses, you could just simply add on a few words here and there, but typically a Canadian Tire store has Canadian Tire written pretty big, and I've seen bigger than that. So you need to add what jardinage, réparation automobile, so many words here and there to double the space of Canadian Tire. There may not be sufficient space on the actual store front, so they may need to, second slide, add some sort of display on the top to make it French. It's just a joke, but still just to illustrate what this implies. Okay, so now moving on, also very quickly, because it's didn't change anything, promotional materials. So the only thing that changed is they added, regardless of the medium used, because before that, you know, some people argued that promotional materials, the law only applied to physical paper or whatever materials, but it was more or less accepted that it also covered electronic materials like websites and social media sites. So they added that just to make sure nobody tries to wriggle around it, but nothing changes. So for promotional materials, website catalogs, flyers, whatnot, everything needs to be French. Everything can be in another language, in a language other than French, as long as the French version is not essentially harder to obtain. For example, you could think that, you know, let's say you're giving out flyers that are in English, and there's a QR code saying if you want the French version to scan with your phone and get the French version, that would not be compliant because it's a little harder. There's an extra step to get to the French version. So if you do everything bilingual equally, everything will be good. Now, conclusion, which is often the first question people ask, what am I at risk for? Well, in theory, there's a $7,000 fine for a person. For a business, it's $30,000. Or a company, and for an actual a director of a company could be personally held liable up to $14,000. It doubles for a second infraction or second offense, and triples the third time and following. But here's the good news: I deal with these situations with complaints on a regular basis. Never, ever have I had a client that had to pay anything or actually receive a fine, because the way it works, you get like a préavis, a pre-notice of non-compliance, and the OQLF says, listen, we saw this, there's a problem, that's why it doesn't comply. Please get back to us with how you plan on rectifying and how long it's going to take. And so as long as you're polite and responsive and showing that you have, you know, good faith intent to correct the situation, as I said earlier, they'll be happy to help you, provide suggestions. So that's useful to know. But also, it's not because you get a notice that you're necessarily non-compliant. As I said, there are many exceptions. There are many more that we haven't discussed today. So if you get a letter, I would say come to a guy like me, and then we could look at it and see if there's something we could do to avoid this, or what needs to be changed, and what we need to do that's the least problematic for the business. So that's about it. I hope I clarified some of the issues. We're open for questions. I don't know if we have some questions already. If not, it's not too late. We have about 10 minutes to go over that. And please don't ask any specific questions related specifically to your business, because for ethical reasons, I wouldn't be able to answer. But if you just keep them general, and that'll be fine. Marie?
Thank you very much, Mr. Pascal Lozon, for this conference, which reminds us of our obligations, give us key information and action to implement with our business partners. We are now entering our question and answer session. If you have not already done so, I invite you to ask your question in the chat tabs. And so, I think I have one. So, if a website appears on packaging, does the website content need to be available in French?
Oh, that's an interesting question. I'm just trying to imagine how if a website appears on the packaging, that is, there would be a photograph of a website on the packaging. I imagine that would be it, and then the website. Well, I would say probably yes, but I would say you could have both. I mean, I would put a picture of both of the French and English version of the website, because I mean, the photo of a website on a packaging is still an inscription on the packaging. So yeah, I don't think that, I mean, it's a question I hadn't thought of before, but thinking quickly, I would say that yes, it would need to be in French, or at least but not exclusively in French. Could be in another language, as long as the other photograph of the website doesn't make it bigger in another language.
Thank you. Jennifer, do you have your answer, or do you need more precision? Sorry, she said, I meant the name of the website.
Oh, okay, or like the internet address, the URL. No, I don't see. I mean, I haven't seen that specifically, but I can't imagine that. Let's say your internet address is an English word or a sentence, like many businesses are. I don't see. Yes, the name of the website. Yeah, that's very good. No, because no, I mean, that would be totally impractical. That would obligate you to find a French version of. No, I can't. I mean, I don't see anything specific about that in anything, but I just simply can't imagine that would be a requirement. If ever it is, we'll fight it. Don't worry.
Okay. So she added also, will the actual website content need to be also in French? I presume it's because the content is in English now, and it should be translated? Is it your question, Jennifer? Yes. Okay.
Would the actual website content need to also? Yes. Okay. That's. Well, okay, this is a very interesting question, because the OQLF takes the position that if you're doing business in Quebec, even if you don't have a physical presence, you need to have a French version of the website. Now, that's their position. It doesn't make sense from an international law perspective, because I mean, Quebec law doesn't apply outside Quebec. And it's like saying, like, let's say I'm a German bookstore based in Germany, and there's some Germans here in Canada, and they sometimes buy books off that website because they want to read in German. That would be totally ludicrous to prevent, like, to sort of block the website because it's not in French. So I mean, that's a very impractical and probably very illegal interpretation. So the answer to your question is no. But if you have a business, and in practice, the OQLF has never taken issue with a foreign or out of province entity that does business in Quebec that doesn't have a French website. So the answer is, in theory, they think yes. In practice, they don't. But if you have like an actual address, a store or something, then that most definitely yes. And I'll give you an example I had to deal with that very question. We represent, I don't know if anybody does camping here, but KOA, which is Campgrounds of America, campgrounds with a K. They have about 500 affiliates across North America, only 4 in Quebec. And so one of the Quebec camping grounds out of Route 20, close to Quebec City, got a complaint because of that. It's specifically, it was being advertised. It was not its website. The website was managed from Montana by KOA, and on the website, they advertise all their campings across North America. But it was the Quebec camping that got the complaint, not and it had no control over the over the website. And my argument was saying is like, listen, if it's not its website, I mean, it has no control. I mean, he pays for, but they were very insistent that it changes, and it kind of put us in an odd position. But still, so eventually we negotiated with the OQLF saying, so they understood that is a US-based company with 496 campgrounds outside of Quebec, and to translate everything would just simply, probably close down the business in Quebec because it was just did not make it profitable for that company to have campings here. So it was agreed that all they needed to translate was like a few introductory pages and the pages concerning the particularly for Quebec campings. So so the answer to your question is yes and no, depending on the situation.
Thank you. I have a question.
I'll read it. In the best soap product packaging example, does the brand name best soap need to be translated into French because the word best and soap are generic descriptive, even if best soap is a registered trademark? Well, I would say yes. But the OQLF, surprisingly, and that's what I mentioned earlier, surprisingly takes the approach that it doesn't have to because it's the name of the product, which honestly doesn't make sense legally or even logically, but that's the position they're taking. So because as I said, the exception to the exception that's coming into place, obligating the use of a French translation of descriptive or generic terms in a trademark was adopted to block people, to prevent people from using that example by registering full labels as trademarks. So probably that's what they had in mind. They didn't formulate it exactly that way. So the actual formulation is broader than the intent, but the interpretation that the government is taking is within the intent. That is not to oblige the translation of the trademark per se. So in answer to your question, I would say no, but we never know if the interpretation of the statute will change. But if it does, be rest assured that there will be much legal and political pressure that things remain the same. So I wouldn't worry about that.
Does it answer to your question, Brigitte? Yes. Okay. Thank you. I have the same question for the other OQLF example for the happy teeth. The bronze is happy teeth, and there is inside of the brown teeth, the word teeth, and in the package is anywhere translated, no translation of teeth. So is it right?
Well, here's because happy teeth is not descriptive or generic of the product being toothpaste, right? Yes, it applies to teeth, but that would be a very, I would say, twisted interpretation of generic or descriptiveness. Because you're sort of implying that if you use that toothpaste, you will have happy teeth, but teeth don't have feelings. How can a tooth be sad or happy? It could hurt. That I've had that before, but no, good question. But I don't know. It's not a problem.
Okay, thank you.
And yeah, and that reminds me of a question that you asked yesterday to our French audience. What is a generic trademark? Because what's generic in some circumstances could be not generic in another. And for example, well, you're in the produce business. So let's say you want to use Apple as a trademark, saying I'm selling apples. I'm gonna put Apple on my bag and say it's a trademark. Well, no, it's not a trademark because it doesn't conform with the definition of the trademark that it's used to distinguish the source of the product. It's used to identify what the product is. However, if I put Apple on my phone, if I put Apple on my tablet or Apple on my computer, well, then it's not descriptive of the product. It's totally unrelated. I mean, so Apple for electronics can serve as a trademark, but not for fruits.
Thank you. We're almost at the end of the webinar. I don't see any more questions, so I suggest to go to the next step. So thank you.
All right, well, good. Now, either nobody understood or it was clear enough. So thank you all for taking the time to interest yourselves in this matter. I think the AQ DFL has provided you with my email address. So if you have any questions, general questions, I'm happy to answer. Specific questions, I'm happy to answer too, but then we'd need to open a file and have a regular client solicitor relationship. But in any event, it was a pleasure speaking with you all, and I hope to hear back from you.
Okay, thank you very much, Mr. Lozon. If you don't get a chance, if you have any question, you can send to the email address of Mr. Lozon on the next and see to his email address. I just have a problem with sharing my my presentation, so no, it doesn't matter. To the address of Mr. Lozon. We come to the end of the webinar. We hope you have learned a little about bill statistics, how to understand and apply it to your company, and you now have some ideas on how to implement it. We sent you the presentation developed by BCF and the link to view the recording. Many thanks to our partner BCF Business Law for hosting this webinar, to our expert, Mr. Pascal Lozon, and to all of you for attending. We invite you to the QPMA's last major event on 2024, the Oyster Party on November 8 at the Club de Golf Metropolitain in Anjou. Let's register for it if not already done. Thank you for listening and a good afternoon, and enjoy some great scares this evening. Bye.